We're back in open session, Madam President.
Yes, thank you, Mr. Leitchi. This is your opportunity to tell the public about your case, and indeed us.
Merci, Mr. Lauchi. Thank you, Madam President. Madam President, Your Honors, dear colleagues, ladies and gentlemen, members of the public who are viewing the proceedings from the gallery, and those who are listening in by way of the internet. I have learned that broadcasting will be resuming, and thus I address everyone throughout the world, and particularly those in Sudan. It is with great humility that the defense rises today to begin presentation of our exonerating evidence in favor of Mr. Ali Muhammad Ali Abd Al Rahman, who is also known as Abu Nasser. We feel so humbled because we realize that this occasion is a solemn one and a serious one. We are the first defense team to address the court during the first trial in relation to the first situation referred by the Security Council to the court. And I'm speaking of the situation in Darfur, Sudan. With, as a backdrop, a bloody conflict that once again ravages this poor country. Since the 15th of April 2023, during this conflict, the same horrors, the same crimes as in 2002 and 2003 are still being perpetrated. The proceedings against Mr. Bahar Idris Abu Garda, Mr. Omar Hassan Ahmad al-Bashir, Mr. Ahmed Haroun Abdel Rahim Muhammad Hussein, Saleh Mohammed Jerbo Jamas, and my client have clearly not been sufficient to deter General Abdel Fattah al-Burhan or General Mohammed Hamdan Dagalo, who also goes by the alias Hemeti, and their respective supporters from plunging their country once again into the bloodshed, the frenzied bloodshed of 20 years ago. Truly, the Sudanese authorities have not learned anything. Such sadness for this great and fine country with a history that goes back millennia, a country that could feed the entire African continent if only the country were left in peace. What a pity for the poor people of this nation who find themselves condemned to endure the endless agony of war after glimpsing for a few months between 2019 and 2021, after glimpsing faint hope of democracy and rule of law. No people anywhere in the world deserves that. The worthy people of Sudan, so cruelly affliged in the past, do not merit this, no more than any others. We have heard from a number of representatives of the worthy Sudanese people before this court. Just this morning, in fact, my first thoughts go to the victims who appeared before the court to express their views and concerns. The tragedy that this worthy people is once again confronted with in the year 2023 is no less tragic. And I would like to begin my pleadings by expressing my thoughts and my deepest solidarity with the people of Sudan, as well as with all the people subjected to violence and worse throughout the world. In another part of the world, actually, 3 members of my team, 2 of whom are present here in the court, saw only a few days ago their own country plunged once again into chaos, fire, bloodshed, and human madness. They are worried about the safety of their family and their friends. Thus, I would not wish to exclude any victim, any martyred people, any member of the international group of civilians struck so harshly by war. I would not want to exclude any of them from my thoughts. This court was established in the hope that repression and the horrors of war would one day come to an end. And one must have the humility to acknowledge that this vain wish is still but a wish, while the twisted minds of this madness continue to turn their wheel, the infernal wheel, and crush their victims, children, women, men, the elderly, both in Sudan and elsewhere. I would like to explain to the people of Sudan what the role of the defense is here at this court. I would like to explain that my client cannot be convicted unless he is found guilty beyond reasonable doubt after a fair trial that is conducted with full respect for the rights that the defense team must uphold. History is littered with far too many examples of these rights being violated in all regions of the world and during all times, thus producing tragedy. In my own country, in the 13th century, a papal edict galvanized the Crusaders against the heresy of the Cathars. Kill them all. God shall recognize his own. This utterance became famous and has been uttered a million times since. Burn the witch, people chanted in Salem in the 17th century. Haksa, Hamsa, and the current Sudanese variation of this fierce cry that we have heard, that we have discovered during this trial. In the year 2004, the presumption of innocence and the right to a fair trial were what was missing for the victims of the Mukjar and Delej executions. The role of the defense is to prevent another injustice from being added to this long list, and above all, not before the International Criminal Court, which was established to embody the universal model of justice, whose calls for a conviction without a fair trial represent a total and utter negation. There is a man sitting behind me in this courtroom. Until his name was first mentioned in an arrest warrant made public by the court in 2007, this man was utterly unknown. He was not a member of the Sudanese government at the time, nor is he now a member of the government. He was not a general commanding any army corps in Sudan. He is not a politician. He is not a tribal chief. This man has spent more than 20 years working within the health services of the Sudanese armed forces. The health services are the people who take care of the injured, the wounded. He was not responsible for conducting fighting or military operations. The highest rank that my client ever held in his life was warrant officer. Moussaïd is the exact word. When he left the army, early in the 1990s, with a medical assistant certificate, he opened up a pharmacy at the market in Garcila, in the Wadi Saleh province in Darfur. Regarding the pharmacy, and given that the public must not think that this was some sort of special or grandiose kind of pharmacy, I'm talking about 4 walls and a roof with some shelving inside where the medications were stored. There was one table as one comes into this pharmacy, and all of this is in the middle of a market in a small town in Darfur. A place that no one outside of Darfur ever heard of before this case began. This man has been accused of crimes that were committed 20 years ago. According to the prosecution's case record, on the 15th of August 2003, the villages of Kodum and Bindisi were attacked during a joint operation led by the Sudanese armed forces and a number of Arab militia. These militia often are referred to with the mysterious name of the Janjaweed, or the devils on horseback. Once again, according to the OTP and their records, between February and March 2004, men from the Fur tribe were arrested and detained, mistreated in the localities of Mukjar and Delej. Some were even executed. What is the connection between the events of Kodum, Bindisi, Mukjar, and Delej on the one hand, and on the other hand, this pharmacist in Garcila? The prosecution is trying to demonstrate that there is a connection, one must pay tribute to their performance. Normally, a pharmacist is not the first suspect that comes to mind when one thinks of events such as the ones that are described in the charges. The OTP could have chosen a much easier demonstration by choosing a suspect whose de jure or de facto authority over the protagonists for the charged crimes was obvious. It could have been a member of the government or a military officer, for example. Instead, the prosecution decided to charge an anonymous pharmacist. This is the first riddle that the defense had to work very hard to solve. And this was not the last of our troubles. I shall begin by giving you an account of the major difficulties that our team came across while conducting our investigations and preparing to present our evidence before my colleague, Mr. Edwards, moves on to more substantive measures. In the OTP's account of the events of 2003 and 2004 in Kodum, Bindisi, Mukhtar, and Delej, the role of the various protagonists has been described perfectly. First of all, who do we have? Omar al-Bashir, the president and dictator of Sudan at the time, who called upon Arab militia to mobilize and to crush the rebellion underway in Darfur. Who else do we have? Ahmad Haroun, Secretary of State for the Interior, who traveled from Khartoum to pass on President al-Bashir's orders. Then we have the local commissioners, Jafar Abd al-Hakam and Abdullah Torsain. They were in charge of representing the government in Wadi Saleh and in Mukhtar. As for the military side of things, we have Major Muhammad Musa Adam Katir Bakit, battalion commander of the 96th Brigade, based in Garcila. We have Colonel Abdullah Himeidan, commander of the Central Reserve Forces, Al-Itiyati al-Markazi, based in Mukhtar. We have the coordinator of the paramilitary militia, the Popular Defense Forces, Al-Difa al-Shabi, from Garcila. We have a gentleman by the name of Abd Al Rahman Dawood Hamouda, also known as Hassaballah, and the military intelligence officer stationed in Garcila, Lieutenant Hamdi Sharaf El-Din. The roles of these various protagonists have been described in the OTP's brief. The brief sets out how Omar al-Bashir issued a call for a counter-insurrection officially intended to fight the rebels of the Sudan Liberation Movement, the SLMA, and JEM, the Justice and Equality Movement. This call allowed for the organization of joint military operations by the Sudanese Armed Forces and Arab militia, made up of the Popular Defense Forces, the Popular Police Forces, Al-Shurta al-Shabiya, and the Border Guards. These operations targeted 4 locations in August 2003, particularly Kodum and Bindisi, and led to the arrest, detention, and ultimately the execution of men who were suspected of belonging to the rebellion in Mukjar and Delij in February and March 2004. Each protagonist that I have listed represents one of the components of this operation. First, the government, Omar al-Bashir, Adnan Harun, Jafar Hadba Hakim, Abdullah Torstein. Second, the armed forces, Major Bakit, Lieutenant Eldin. And third, the militia, Hasaballah. No one was missing. And yet, the Office of the Prosecutor added one last man to this list of protagonists, Ali Kushayb, saddled with the mysterious title of Agid al-Ogada. This person, Ali Kushayb, was not a government official, nor was he an officer of the armed forces. The OTP has never claimed that he was a member of the Popular Defense Forces or the Popular Police Forces or the Border Guards. Yet this perfect stranger has been described by the Office of the Prosecutor as the conductor, the great organizer of all these people. According to the Office of the Prosecutor, he was allegedly responsible for directing and commanding all the operations. He dealt directly with the highest placed members of government. He had authority to give orders or exercise influence upon officers from various armed groups. He allegedly recruited and commanded thousands of militia men and liberally distributed weapons, equipment, and money to them. And who is this eminent military leader, this all-powerful leader of the Janjaweed, according to the OTP? No other than Mr. Abd Al Rahman, a pharmacist in Garcila. If, rather than being a pharmacist, Mr. Abd Al Rahman had been a tailor, the prosecution's case would have been nothing else than a Sudanese variation of a famous fairy tale by the Brothers Grimm. And how did it come to be that the prosecution added this anonymous figure to the list? This list of protagonists in the events of 2003 and 2004. Where did this person come from? Why him? And none of the other men that I previously mentioned, whose de jure and de facto roles were clearly established by the administrative and military organization prevailing at the time. Why did the OTP trouble themselves to show the significance of this mysterious Agid al-Ogada rather than referring to the clearly defined titles and functions of Secretary of State, Commissioner, Major, Colonel, Lieutenant, or Coordinator? Why did the Office of the Prosecution decide to go fishing in these murky waters while there were big fry who were swimming right under their noses in crystal clear water? The defense has asked this question time and time again. ever since the beginning of this case and throughout the trial. We have our answer. We have found our answer, but this answer was hidden in the thousands of documents received during disclosure of evidence by the OTP without any description of its importance. And the importance of this point escaped us too. But another document disclosed by the OTP on the 5th of October 2023, scarcely 2 weeks ago, finally has shed light on this matter, the importance of this document. I refer to a letter by the prosecutor of the day, Luis Moreno Ocampo, dated 6 November 2006, car DTP 00005596. In this letter, the prosecutor asks Sudanese authorities to give him the names of people who are being investigated for crimes committed in Darfur. And what was the purpose of this letter? He wanted to make sure that his own investigations would not clash with the principle of complementarity. We have already seen the response from the Sudanese. I refer to a letter dated 9 December 2006, bearing the reference number DAR OTP 01230002. In this letter, the authorities forwarded the prosecutor a list of 14 people. Only one of the names that I mentioned earlier is to be found on this list. The lowest ranked person of all the ones I have mentioned. Here we read Amdi Sharif Eldin, bracket, an officer of the armed forces, bracket. He was the military intelligence officer in Garcila. The 13 other names are names of people who are utterly unknown. One of the names is Ali Muhammad Ali Abdul Rahman, also known as Ali Koshein. There is no mention of his duties, no mention of his title, or whether he might belong to any military or paramilitary faction. Nor is there mention of his date of birth, the place he was born, no mention of his place of residence, no mention of his profession. The person referred to in the letter of 9 December 2006, named Ali Muhammad Ali Abdul Rahman, also known as Ali Koshein, is a perfectly anonymous figure. This is the first time that he appeared on the record of the case. A pharmacist in Garcila would not have been more known, and yet, no doubt, this is one of the coincidences that the sleuths of the OTP relied upon to demonstrate his identity with my client. Since they are both unknown figures, they must be the same person. And so, you see, it was the Sudanese authorities who threw out his name to the wolves of the OTP as a person suspected of crimes committed in Darfur. But the letter of 9 December 2006 makes no mention of President al-Bashir, no mention of Defense Minister Hussein, no mention of the Secretary of State for the Interior, Ahmad Haroun. The Sudanese authorities gave the prosecutor of the court barely anything, merely the names of the small fry, and thus they protect their senior dignitaries, even though they are the ones who bear primary responsibility for the events in Darfur. So to turn the prosecutor's attention away from the people primarily responsible for the events, at least for a few moments, the authorities decided that the person who would be designated as the primary accused person for these crimes would be the pharmacist from Garcila, the one with an alias that does not belong to him. Just to add to the confusion, some of the people in the OTP might have been troubled by this anomaly, but after all, we are talking about the year 2006. At that time, the strategy of the OTP was to go after the small fry in order to pluck the low-hanging fruit. Once a trial was over, a trial that shouldn't take very long, so that the new International Criminal Court might quickly prove itself, prove its efficiency. I think we remember that this was the justification of Luis Moreno Ocampo for charging Thomas Lubanga Diolo. Indeed, in the year 2006, since then, we have seen the results in terms of easy convictions and fast trials. This perfectly anonymous figure, saddled with the nickname Ali Koshin or Ali Kushaib, who cares how it's pronounced? So this person, this was a real deal, a bargain for the OTP when it came to following their strategy. Alongside the true challenges, ministers Ahmad Haroun and Mohammed Hussein and President al-Bashir. Too bad that it makes no sense to charge a simple pharmacist with suddenly becoming an all-powerful warlord. And yet, there is a certain logic for the authorities of Sudan. It makes sense for them to accuse this pharmacist from Garcila for the crimes that occurred in Darfur. The first advantage for them, of course, was that they were able to draw the prosecutor's attention away from those who bore primary responsibility. One can understand this logic. One merely has to consider the etymology of the word pharmacist. Pharmacist comes the Greek word pharmakos. The pharmakos, before this person was the person who sold medications, was actually the person who was sacrificed in atonement for the sins of others. This is a translation in Greek of the Hebrew tradition of the goat for Azazel, which in modern language gave rise to the word scapegoat. This Hebrew tradition originates in Leviticus chapter 16, verses 21 and 22, which I shall recite to illustrate the logic of the Sudanese when they accused Mr. Abd Al Rahman. Aaron, here we shall pronounce it Harun, shall lay both his hands on the head of the live goat, confess over it all the iniquities of the children of Israel. In this case, we could speak of the Sudanese authorities and all their transgressions concerning all their sins, putting them on the head of the goat, and shall send it away into the wilderness by the hand of a suitable man. Let's say Luis Moreno Ocampo. The goat will carry on itself all their sins to a remote place. Let us call this place the Netherlands. As you can see, accusing this pharmacist from Garcila of all the iniquities of the Sudanese authority, this made perfect sense. If you follow this fine logic, Your Honors, and you will assuredly convict Mr. Abd Al Rahman. Yet, obviously, when the goat rebels and rises up against this fine logic, and instead of placidly allowing itself to be sacrificed, when this scapegoat decides to rebel and voluntarily surrenders himself to the court to seek justice, and these were the very words of Mr. Abd Al Rahman when he first appeared before the court. And when he dares to conduct investigations to prove his innocence and to demonstrate that the Sudanese authorities merely made fools of prosecutor Luis Moreno Ocampo and his teams by drawing their attention away from the people who were truly responsible for the crimes in Darfur, that goes against the greatest traditions of the good book. This is intolerable. And indeed, this was not tolerated by the Sudanese authorities. The defense received no cooperation from the Sudanese authorities during our investigations. No cooperation, no responses to our requests for judicial assistance. The purpose of these requests was to obtain essential documents such as the civil status documents of Mr. Abd Al Rahman, his military records, or his criminal record. Ever since we were designated in June 2020, and despite our constant requests, the defense has received but a single visa valid for 30 days to travel to Sudan. And obviously, we rushed, and we did travel there in June 2022. We were allowed only to travel to Khartoum, which is very far away from Darfur, where our investigations had to be conducted. So naturally, the defense complained to the court about this state of affairs, the lack of any response for our requests for documents, and the lack of visas. The first application in this regard dates back to the 20th of January 2021, quite a long time ago, and this was a request made to the pretrial chamber. The application bore the number 263. There is a public version thereof. It was dismissed, as being without any ungrounded, without leave to appeal. That was just the first. For months, all the requests, both written requests and oral ones, to make a finding of non-cooperation by Sudan, all these requests were systematically dismissed by your chamber, and the requests, rather the applications for leave to appeal, were also denied. Your chamber asked Sudan to justify themselves, granting them a certain amount of time, then another delay, yet another delay. Time went on, and the defense remained blocked, unable to conduct investigations, even when your chamber made a commitment to take decisions once the observations from Sudan had been received. I refer to paragraph 14 of your decision 695, dated 24 May 2022. There is a public redacted version. Ultimately, the chamber did not do so, and ultimately, once again, the defense had to make yet another request. Because the defense continued to insist, time and time again, ultimately, the Sudanese authorities were forced to cooperate. Were they going to provide the documents that were indispensable to the defense of Mr. Abd Al Rahman, documents that could prove that our client was completely innocent and that they had made a mockery of prosecutor Luis Moreno Ocampo and his teams by giving them a false lead? No, of course not, because that would threaten the impunity of the authorities who truly bear responsibility for the crimes that Mr. Abd Al Rahman has been charged with. No question of running such a risk. Thus, the Sudanese authorities decided to escalate matters. The escalation took the form of a communication dated 12 January 2023. As I prepared my opening remarks today, I asked for leave to reveal the content of this communication in public. I refer to filing 1029 dated 6 October 2023, and I do note that there is a public redacted version of the filing. The OTP opposed the request in filing 1031. The prosecution feared that making this escalation on the part of the Sudanese authorities public, there could be serious consequences for their investigations underway in other Sudanese cases. I referred to filing 1031, paragraphs 10 to 12. How can Mr. Abd Al Rahman's right to have a trial held in public be dependent upon the hopes of the OTP investigating other cases? Would it have been better to have asked the Sudanese authorities for their opinions, or should...
I'm very sorry to stand up, but he is getting so close to the line. I won't say more in public session. It's absolutely irrelevant to anything, and we can go into private session if we want to discuss this, but I have to stand up the way this is going.
I was beginning to wonder, Mr. Lightshare, about this. Unfortunately, I didn't read far enough ahead to see what you proposed to say. I don't really think this is... what is a complaint, effectively, one which you've repeated, is really telling the public about what your case is. and you are beginning to tread a very fine line, as Mr. Nichols says. I mean, if you want to argue it, then I think we'll go into private session.
Cela ne sera pas nécessaire.
This won't be necessary, Your Honor,
Mes deux yeux
but
sont braqués sur la ligne.
eyes are, yes, indeed, looking very closely at that line, and the line shall not be crossed over. I refer to my client's right to his case being heard in public.
Yes, but just a moment. Are you proposing, you're on page 12 of your opening, as far as I can see. Yes. Are you proposing to finish the paragraph, the long first paragraph on that page?
That's my intention, Your Honor.
Mr. Nichols, were you provided with a copy of what he was going to say?
No, Your Honor.
All right, I'm sorry, Mr. Leitch, I think we will have to go in. I'm sorry to interrupt you, but we will go briefly into private session.
We're back in open session, Madam President.
Yeah, thank you. Yes.
La conséquence
Mr. Lauchi, the consequence
de la communication du 12 janvier
of the communication of the 12th of June 2023 was that
que la défense
the defense did not obtain the documents that we were requesting and had to give up on the idea of traveling to Sudan for once and for all, or subsequent to this communication, the defense would have been running the risk of being arrested or abducted.
Je rappelle au passage,
Incidentally,
une parenthèse,
this is a sidebar, so to speak, the previous registrar of the court was of the view that he was not bound by the slightest duty of care
à l'égard des membres de la
for members of the defense team. This position was set out in a letter dated 22 March 2022 and is to be found on the case record under reference number 643 Annex B.
J'invite tous ceux qui se préoccupent des droits
I would call upon all those who are concerned about the rights of court counsel working before the court and their associates to refer to this. People who are concerned about their rights and working conditions. This absence of duty of care means that, unlike the court officials arrested in Libya in 2012, unlike OTP staff members, the members of the defense teams who have to buy a personal insurance policy for each one of their missions, this implies they can not count on any assistance from the court if they are arrested in Sudan or disappear in that country. Under these conditions, it goes without saying that the escalation of the 12th of January 2023 signaled the death knell of the slightest hope that the defense team members could deploy to Sudan, and it also meant that the defense had to find other solutions to conduct our investigations. Once again, this is another aspect of the violation of the principle of equality of arms, which did not result in the chamber intervening and correcting the matter. The escalation of 12 January 2023, no matter how intolerable, prejudicial to the rights of the defense, no matter how unjustified it may have been, was yet accepted without anyone batting an eyelid. And this allowed Sudan to benefit from yet another delay to rationalize their actions. I refer to decision 853 of 20 January 2023. In response, you asked the defense to shorten our list of documents requested of Sudan. Your decision 857, 27 January 2023. I recall that at least twice, paragraph 13 of your ruling 695 of 24 May 2022 and paragraph 18 of your decision 806 for December 2022, the chamber did find that obtaining the documents requested by the defense was essential to ensure the principles of a fair trial and equal arms. But in response to the escalation by Sudan on the 12th of January 23, which infringed upon Mr. Abd Al Rahman's right to prepare his defense, the chamber gave up on upholding these principles and opted for appeasement, appeasing Sudan. As history shows us, a strategy of appeasement is naturally doomed to failure, and that is exactly the outcome that we saw. Your ruling 853 was simply ignored by Sudan. There was no answer to the reduced requests from the defense. And Sudan did not even deign to appear when summoned to attend the hearing of 19 April 2023. And then what happened? Your chamber paid lip service and found that Sudan was non-cooperative, but refused to resort to the only mechanism set out in the Rome Statute to force the country to cooperation, and I refer to the possibility of a Security Council referral. Use of this mechanism was requested by the defense. Decision 913 of 31 March 2023, and a public version of this ruling was registered on the 31st of May 2023, turned down this request. Refusal to make use of this mechanism has deprived the defense of its only solution under the core legal texts of the court to obtain cooperation. Sudan, particularly the granting of visas to investigate in Sudan and documents that are essential that they have requested since November 2020. Your chamber has certainly not been curious. The chamber recognized the essential nature of some of these documents, but gave up rather easily on seeing them. All the same, I will provide some illustrations to show that these documents are essential. The defense asked for disclosure of Mr. Abd Al Rahman's civil status documents. Not only were these documents essential to verify the nickname Ali Kushaib, a name by which he is charged, but also the court has been asking for these documents in order to assess whether my client is indigent. and whether he is eligible for legal aid paid by the court. The OTP passed on those requests. Nothing was obtained, and during your deliberations, you will have to do without these essential documents to verify the alias. Secondly, the defense asked for disclosure of Mr. Abd Al Rahman's military records, records that could very well contain evidence of his partial alibi for the events of February and March 2004 in Mukjar and Delej. The Sudanese authorities refused to provide the document. The OTP also passed on the request from the defense and did not receive the documents either. Once again, your deliberations will, as you deliberate, you will have to do without this essential document to verify whether or not Mr. Abd Al Rahman was present in Mukjar and Delej in February and March 2004. Third, the defense also requested disclosure of Mr. Abd Al Rahman's criminal record. This is something you could call Criminal Investigation 101, the very basics. This document was also essential insofar as the Sudanese authorities claimed that my client was the subject of proceedings in 2006 in relation to the Darfur events. Those proceedings should be found in his criminal record, so the request was legitimate. It was essential to obtain this document in any country, anywhere in the world. A person's criminal record is the first document that is placed on the record of the case. The OTP never asked for it and merely passed on the request from the defense once again, for which there was no answer. And nothing was obtained. There was no response. Once again, during your deliberations, you will have to do without this document so essential to verify the identity of Mr. Abd Al Rahman, alias Ali Kushaib. Finally, the defense requested disclosure of public documents, such as the rules of engagement that prevailed within the Sudanese armed forces. And the defense has been troubled by the fact that the OTP never thought to request disclosure of this essential document and made a request for the first time only when passing on the request from the defense. Is this really how investigations are conducted concerning allegations of crimes committed during military operations, particularly when one considers just how essential this document is, the rules of engagement within the armed forces. Any other court would have demanded them. This is not very professional. It is never too late to finally do a good job. The OTP did pass on the request at the request of the chamber and did not get anything by way of rules of engagement. Once again, when you deliberate, you will have to do without this essential document. This document so necessary to understand the conduct of military operations that are mentioned in the charges. Your chamber found that these documents were essential, but refused to implement the means provided for by the statute of the court so as to obtain them, thus failing to meet your obligation to ensure a fair trial under Article 64(2) of the statute. Facing the considerable doubt that the lack of all these documents maintain on the substance of the matters that you will adjudicate, how will your chamber apply the principle of indubio pro reo, found in Article 66(3) of the statute of the court. Will this principle be affirmed once again, but not given body, as already has been the case, as was the case with the principles of a fair trial and equality of arms in rulings 695 and 806, which I've already mentioned? The impossibility of obtaining essential documents that the defense has asked for was favored by your chamber's refusal to do what it could and should have done to ensure a fair trial. Under Article 66(3) of the statute, the lack of these documents can result only in the acquittal of Mr. Abd Al Rahman of all the charges standing in his name. And I see the time, Your Honor, and I would suggest leaving it at that for this afternoon.
Yes, well, I was about to stop this diatribe at this stage as well, Mr. Loche. Yeah, we will go into private session, please.